Good evening, welcome. I'm Michael Schutzen from the Communication Department at UCSD, and I'm very pleased to be introducing our speaker this evening. About 4 months ago, the lead story in the New York Times business section was all about the man I'm about to introduce. Norman Pearlstine announced his retirement as the 5th editor-in-chief of Time, Inc., the magazine empire begun in 1923 by Henry Luce. This is one of the biggest jobs in the big world of big media. Time, Inc., whose flagship magazine we all know, and whose other star magazines include People, Sports Illustrated, Money, InStyle. These are well known too. It's a vast publishing world. 13,000 employees, 155 magazines. Those magazines are read each month by roughly 2 out of every 3 American adults. They take in 1/4 of all U.S. consumer magazine advertising revenue. And Mr. Pearlstine was the editor-in-chief of all 155 of them. Mr. Pearlstine is a graduate of Haverford College, a small liberal arts college just outside Philadelphia. He went there because he grew up not far away and because Haverford had one of the worst football teams in the country. He thought he would have a chance to make the team. He turned out, I understand, to be wrong about that, but that was okay. There were other good things at college. He told Esquire magazine, "I learned to drink. I learned to go out and party." So college, even without football, had its own rewards. From Haverford, Pearlstine went on to the University of Pennsylvania Law School. A law degree seemed an unlikely qualification to be copy boy at the New York Times, but Pearlstine had decided he was eager for a career in journalism and not for a job in his father's law firm. In journalism, law degree or no law degree, you tend to start at the bottom. He didn't stay there long, however. He moved up to news assistant, in which job he proofread captions on photographs, working a shift from 6 p.m. to 2 a.m. It was not the bottom, but it was pretty close. So when he got an offer to be a reporter for the Dallas Bureau of the Wall Street Journal, a newspaper he had never read, he grabbed it. Well, it appears he was a pretty quick study. He was with the Wall Street Journal for most of the next 25 years as a reporter in Dallas, Detroit, and LA, as Tokyo bureau chief, the first managing editor of the Asian Wall Street Journal, the first editor and publisher of the Wall Street Journal Europe, and finally managing editor and executive editor of the Wall Street Journal. For those of you here who might be thinking about careers in journalism, something Mr. Pearlstine wrote about his own career some years ago seems to be worth noting. "I loved reporting," he wrote, "but I found writing, while immensely satisfying, very painful. It still is." He also said, contrary to what we tell you over and over again here at the university, that in most people's careers, luck and chance play a greater role than most successful people want to acknowledge. That may be, but it's not all luck and chance. And Mr. Pearlstine rose from one top position to the next because he did his work remarkably well. But what is that work? What does a top news executive do? What does any top executive do? I don't know, because I've never been a CEO or an editor of 155 magazines at once. Norman told us at lunch, over lunch today, in fact, that he was trying to keep it a secret. But it must have something to do, it seems to me, with the sign on Harry Truman's desk. "The buck stops here." Making the tough decisions expeditiously and wisely would seem to be the task of the executive. And so last summer, it was Mr. Pearlstine's task to figure out what to do about Matthew Cooper, a Time magazine reporter, and whether Mr. Cooper should testify before the grand jury in the Valerie Plame, Judith Miller, Scooter Libby, Robert Novak, Patrick Fitzgerald, Karl Rove, Dick Cheney, weapons of mass destruction, anonymous source leak case. It must have a shorter name. Mr. Pearlstine says that the Cooper decision was the most difficult he made in 3 decades in journalism. And he's still thinking about that decision, working on a book to be published next year entitled On the Record, The Use and Misuse of Anonymous Sources. Thanks to the generous sponsorship of the Helen Edison Lecture Series, the kind intervention of T. George Harris, the gracious and capable management of Edie Monk, Mr. Pearlstine is here to address us on that vital topic, and it's a pleasure and an honor to give you Norman Pearlstine.
Well, Michael, thank you very much, I think, for that introduction. Only a Swarthmore graduate would talk about my football career at Haverford, but that's only because we lost to you all 4 years that I was there, and I think dropped football about a year after that. It is actually a great pleasure to be here in San Diego. Among their 155 magazines, there are a few up the road in Oceanside that are among my favorites. Skateboard, magazines on surfing, on snowboards, freeze, BMX, motocross, all part of Trans World Publishing, which we acquired from Times Mirror Group in the year 2000. So it's good to be in the neighborhood where some of our titles are. I also thought it particularly appropriate to speak about this subject here in San Diego, since the Union Tribune, following my decision to turn over the paper to the special prosecutor, had a cartoon on the editorial page that said Norman Pearlstine, Wimp of the Year, making it look like the Time Person of the Year, and that's actually a cartoon I treasure and delighted to have in my collection. But then again, given that Time magazine ranked Dick Murphy as one of the 3 worst mayors in America, it seems only fair that the Union Tribune feel the way it does about me. I think we both sort of compete for who was responsible for his decision to resign, but nonetheless, when I think about San Diego, I do think about that story. And of course, to be in this building, where outside our publication Sports Illustrated gave you the credit for having the best surfing program in America, how could I not want to be here and speak about this subject? But actually, before coming today, knowing that I was going to be speaking about the subject of a book I'm working on, Off the Record, the use and misuse of anonymous sources, I called up Dick Cheney this afternoon, and I said to him, well, Dick, there's been a report going around all week that you were drunk on scotch when you fired that shotgun. And there was a silence that come to understand from Dick, and he said, well, he said, off the record, there was no alcohol, and on deep background, it was bourbon, and not for attribution, Whittington was the one who was drunk, not me, and that's why he was where he was. And on the record, I don't drink and I don't own a gun. So I mention that only because I think that in talking about the subject that has taken over my life over the last couple of years, one has to recognize that it is not just about what editors do and what reporters do, but increasingly a subject that touches really the heart of what we as a country are all about, very much about the relationship between journalism and government, very much about the integrity of what we say to our readers or our viewers, and the kind of relationship that we have with them. I personally think that the most important story of my lifetime was Watergate, a story where the Washington Post particularly led the coverage, and where the cooperation of a source who became known as Deep Throat and who turned out, we now know as Mark Felt, the number 3 person at the FBI, could not have been done without confidential sources. And Felt was not doing this because of his great concern about the future of the republic, was mad that he'd been passed over by Nixon and not been chosen to run the FBI. So the motive of the source is not a particularly important one. I do think that as a consequence of the success of the Washington Post with Deep Throat, we did develop a generation of journalists, myself included, who thought that the most important, honorable thing a journalist could do would be to get the kind of big story that came from an anonymous source. And I think as a consequence, we developed a pattern in journalism where there was actually more willingness to trust someone who was off the record than someone who was speaking on the record. This is contrary to what a lot of the general public might think. I think an awful lot of people will read a newspaper or a magazine and will take a look and say, well, gee, they say a source said, they must have just made that up. Whereas we as journalists, if you're interviewing somebody for 10 minutes and you're on the record and you finally ask a question and the source says, gee, can we go on background? You think, he's finally going to tell me something of use, because on the record he's been spinning me the whole time. And I think that also as a consequence of a generation of journalists thinking that getting a deep throat to tell you the great story is what journalism is all about, the government has figured out how to play the game. And so we now live in a culture, especially in Washington, where a Deputy Assistant Secretary of Defense being asked how many people were killed in Iraq yesterday will say, well, I can't answer that on the record, I'll have to go on background. And I thought that I understood all this. I've been a journalist. I started really as a summer intern between my freshman and sophomore year in college in 1961. I've worked full-time in the business since 1967. And I thought I really understood everything one needed to know about sourcing, about what these various terms mean, such as off the record or not for attribution or deep background. And it was only when we got involved in the Valerie Plame case, a most improbable case, that I found myself having to reconsider everything that I thought I knew about journalism. And while the Matt Cooper involvement in that case, and indeed the Valerie Plame case itself, are by no means the most important examples of where anonymous sources have played an important role in journalism, even since then, the national security, the NSA case and the New York Times on wiretapping, or the Washington Post story on CIA torture camps in Eastern Europe, all relied on confidential sources. But it was really through this exercise that I came to think a lot about journalism and about many of the preconceptions that I had, a lot of which I've found myself abandoning. As some of you may know, just in terms of background of how this case got started, when George Bush decided to go to war in Iraq, in his State of the Union speech in January of 2003, he listed three major concerns about Iraq: weapons of mass destruction, links with Al-Qaeda, and efforts to buy uranium or yellow cake in Africa to rebuild the nuclear program. And the 16 words in the State of the Union speech that came from British intelligence talking about this led to a lot of skepticism on the part of people in Washington who felt that, first of all, the Iraqis already had uranium, and secondly, while they might have been working on weapons of mass destruction, their ability to create an atom bomb was really pretty far off. One of the people who was most upset by Bush's assertion was a former diplomat named Joe Wilson, who had been sent to Niger in 2002 by the CIA to pursue these rumors. And when he got there, he found that, in fact, all the uranium in Niger is controlled by a French consortium, and he was assured that none of it had been sold to the Iraqis and that there was nothing to this report. He came back, he told this to the CIA, and he was stunned when he saw that this was one of the three reasons that the president was asserting to justify going to war. After talking off the record to a couple journalists, he wrote an op-ed piece in July of 2003 that basically talked about what he learned in Africa and why he thought there was nothing to this case. And what we've now come to understand is that the so-called Iraq group around Vice President Cheney was really very upset about this article and about both the political and the military implications of what he was saying, and that one of Cheney's chief assistants, Scooter Libby, told a number of reporters, either whom he called or who called him seeking comment, that the story that Wilson wrote really didn't have all of its facts correct, and that if anything, he couldn't be trusted because his spouse, who worked at the CIA, had something to do with his making the trip. This, of course, assumes that a trip to Niger for no pay is a boondoggle that people would look forward to doing, but nonetheless, that led Robert Novak, a syndicated columnist through the Chicago Sun-Times, to write a column that appeared in July of 2003, stating that Wilson's wife, who used the name Valerie Plame, had been involved in sending him to Niger. About the same time, one of our reporters, Matt Cooper, a veteran investigative reporter who'd been working in Washington for 20 years, he'd worked at New Republic, he'd been deputy bureau chief of Newsweek, he'd been our deputy bureau chief before going to work at the White House, wrote a piece for our website that essentially said confirmed much of what Novak had written, but also questioned the motives of the people who were leaking the information about Plame. When I saw that story, I frankly did not react to it as saying, boy, this is really the great scoop, this is the next Watergate or anything like that. In fact, it seemed to me sort of like business as usual, that one of the things people in Washington do is talk off the record, trashing anybody else, and the infighting between the CIA and the White House over Iraq was pretty well known. A lot of the CIA people were very cautious about the doctrine of preemption and the decision to go to war. The White House thought that state and CIA was full of people who never recovered from Vietnam and didn't really understand what was at stake post 9/11. And so we put the story on our website, but we didn't even put it in Time magazine. Nonetheless, the whole issue of Valerie Plame's outing became an issue of importance to people within the CIA, and certainly to people on Capitol Hill, and to a number of editorial writers who thought that that we needed to have an investigation to pursue who did this outing. That led the Justice Department and the FBI to interview a number of people in Washington, not journalists, about the leak. And at the end of December in 2003, the Deputy Attorney General named Patrick Fitzgerald, a U.S. attorney from Chicago, the U.S. attorney for the Northern District of Illinois, as a special counsel to lead an investigation into these leaks. This was a bit unusual because we had had a special counsel law for many years. In 1978, we passed a law creating the special counsel, and Lawrence Welsh, who had looked at Iran-Contra, was a special counsel. Ken Starr, most famously looking at Bill Clinton, Monica Lewinsky, and so forth, was another. But people had come to view the special counsel as somebody who spent a lot of money looking for all kinds of stuff and usually didn't come up with very much. And in 1999, the law that authorized the creation of special counsels lapsed. The one exception, which continued, was whenever the Attorney General felt that there was a conflict between his doing his job and an investigation, that a special counsel could be named. And John Ashcroft thought that since the Justice Department and the FBI were looking into members of the Bush administration that he had worked closely with, that he had to step aside. And that's when Pat Fitzgerald came in. In May of 2004, Matt Cooper received a subpoena asking that he testify, and we were told unofficially that we wanted to know about Scooter Libby. We also learned that others had been served with subpoenas as well. Tim Russert at NBC News, Glenn Kessler, and Walter Pincus at the Washington Post. And in all those cases, the individual reporters had basically cut deals with the special counsel to testify after getting a waiver from their sources who said it's okay to testify. We initially decided to resist it. We were held in contempt by a district judge. Both Matt Cooper and Time Inc., a division of Time Warner, were held in contempt. And at that point, Matt had a conversation with Libby and said to him, you know, I'm treating you as a confidential source, but the truth is you didn't mention Valerie Plame to me in our conversation. Would it be helpful to you if I testified to that effect? And his lawyer called our lawyer and said, please testify. And so Matt ended up testifying, and we thought that was sort of the end of our case. But in Matt's testimony, he indicated that there was more than one source and that Libby was not his only source. And so the special counsel came back to us a few weeks later and said, okay, we heard from you about Matt Cooper, but now we want to know about your other sources. And we, again, refused to identify our source and decided to litigate it. Meanwhile, in an even more surprising move, the special counsel also subpoenaed Judith Miller, a Pulitzer Prize-winning reporter from the New York Times who'd written a lot about weapons of mass destruction. And what was curious there was that Miller never wrote about Valerie Plame. And so we were trying to figure out what did the special counsel want to know from her, given that she'd never written anything. But she also decided to resist the special counsel, and we started litigating this in the courts. And my initial reaction was that I'd seen a lot of subpoenas over the years, whether it was from private plaintiffs, whether it was from district attorneys, whether it was from special counsel, and that rather routinely we in journalism just took the position that, you know, if you give a confidential source your word, that's it. You fight as hard as you can in the court. If you're held in contempt, your reporter goes to jail, you pay the fine, but you don't go back on your word. The people have been trying to get confidential sources from journalists as long as the Republic has been around, and it's just something you don't do. And I really didn't pay a whole lot more attention to it for quite a while until we started arguing this case first in the district court, then in the Court of Appeals, and we lost in both cases. And it became pretty clear to me as we were going to file a petition with the Supreme Court asking the Supreme Court to hear the case that maybe I ought to pay a little bit of attention to the law. And as Michael said in his introduction, I had sort of fled from the law, finishing at Penn in 1967, vowing never to return. And I instead found myself really buried in cases for a couple months trying to figure out what this was all about. So much so that my wife Jane, who's here tonight, said to me, I went to bed with an editor and I woke up with a lawyer. What happened? And that was not meant as a compliment, I might add. But when I started looking at the cases, I found a whole lot of things that made this very complex. One is that while most of us think that the First Amendment gives the press protection to keep sources confidential, the reality is that in 1972, the Supreme Court in a 5-4 decision called Brandsburg v. Hayes held specifically that the First Amendment does not apply to journalists' efforts to keep their sources confidential, and secondly, that in the case of a grand jury, the rules of evidence require, as the court held it, that the testimony of every man be available to prosecutors, and that reporters are no different from any other citizen. I'd known about Brandsburg a little bit because despite the name Brandsburg, it really involved 4 different cases, 2 involving a journalist at the Louisville Courier-Journal named Paul Brandsburg, who had witnessed people making hashish and and had written about his observations of what they were doing. The most important case of the four that were consolidated in Brandsburg was a California case involving a reporter from the New York Times named Earl Caldwell, who had been hanging out with the Black Panthers in San Francisco and who had heard all kinds of threats of violence from the Panthers, and as a consequence, a U.S. attorney for the Northern District in California had wanted Caldwell to tell him who he'd heard saying what, and he had resisted that. The Ninth Circuit Court of Appeals, in fact, had ruled that Caldwell did not have to speak to the U.S. attorney, and so he was a part of this case as well. And what was clear that in the Brandsburg case, we had examples, if you will, where reporters were witnessing either crimes or threats of anarchy and violence, and the court was, if you read the opinion, you'll see, was really quite spooked by the kind of information they had. And Justice Roberts, who had actually been thought of as quite a good friend of the press, just said, when it comes to a grand jury, there's no First Amendment protection. The dissent, the four people who voted against it had different reasons for doing so. Most of them wanted to suggest a balancing test that said we ought to look at this on a case-by-case basis and we shouldn't have this firm a rule. What complicated things was that Justice Lewis Powell wrote a concurring opinion with the majority. He voted with the majority that the reporters would have to speak to the prosecutor, but then he wrote in his concurring opinion that there should be a balancing test, and if you applied a balancing test in these cases, they ought to talk. As it turned out, none of these reporters ever did speak to the prosecutors, and none of them went to jail. Paul Brandsburg left Louisville, moved to Detroit, where he went to work for the Detroit Free Press, and the governor of Michigan refused to extradite him. The special counsel in the Caldwell case and in the fourth case involving a fellow named Pappas, the district attorney there, just decided that it wasn't worth going after them, having won this case. So there never was anybody going to jail. There was never anyone paying any kind of fine. But Brandsburg became a case that civil rights lawyers have had to deal with, First Amendment lawyers have had to deal with over the last 30 years. And so far, that case has never been overturned. And that was the first thing that I understood. The second thing that was kind of baffling to me was I was trying to figure out why we had a special counsel here and what this case was all about. And Patrick Fitzgerald is a very good U.S. attorney and a very smart, very ethical man who takes his obligations seriously. He had been an assistant U.S. attorney in New York where he had prosecuted some of the early members of Al-Qaeda who were involved in the first attack on the World Trade Center in the early 90s. He had actually indicted Osama bin Laden in the mid-90s, although obviously was never able to bring him to trial. And since going to Chicago, had indicted a former governor, had been involved in a lot of high-profile cases, and we knew he was taking his job seriously. But I couldn't figure out what law had been broken. The most obvious one that people talked about was something called the Intelligence Identities Act of 1982, which some of you may remember grew out of the work of a former CIA agent named Philip Agee, who had a magazine called Counterpoint that made a point of trying to name as many CIA agents overseas as possible. And a law was passed basically to stop Philip Agee from printing names in Counterpoint. The station chief in Athens had been assassinated about the same time, and a lot of people in the public mind sort of thought that somehow Agee was responsible for this. But one of the aspects of the Intelligence Identities Act was that you had to have been overseas, working overseas, during the 5 years prior to the time that someone thought the law had been broken. And in fact, Plame had moved from Brussels back to Washington at the end of 1997. So I was a little bit stumped by that part. I was also stumped by the fact that the Privacy Act, which might have had is a misdemeanor with no jail time, and it seemed to me a little excessive to name a special counsel to bring a case under the Privacy Act. And the most confusing thing of all was that Tim Russert, in a press release that he put out after testifying as special counsel, said that he had not told Scooter Libby, Cheney's assistant, who Plame was. And I thought this must have been a typo. I thought this doesn't make any sense. Clearly what he meant to say was that Libby hadn't told him who Plame was. But in any case, with all of this confusion going on, I continued to look at cases to see if there was a way out of Brandsburg. And I looked at the Pentagon Papers, which was a famous case in 1971 where Daniel Ellsberg, who had worked at Rand and Santa Monica, who had kept voluminous notes on the Pentagon's activities in Vietnam, had leaked the Pentagon Papers to both the Washington Post and the New York Times. And I thought, well, gee, that would be a good precedent to look at. But when I went to it, I saw a couple interesting things. One, it wasn't a case about confidential sources. Nobody was looking for Dan Ellsberg. I had that confused in my own mind. It was really a case where the Justice Department under John Mitchell was trying to restrain the newspapers from publishing the article. So it was a prior restraint case under the First Amendment. Even more surprisingly, both the New York Times and Washington Post said in their publications that if the Supreme Court ruled against them, they would cease publication. And I think a lot of people forgot that. In fact, the court voted 6-3 in favor of the right to publish, and the Pentagon Papers indeed were published, and nobody ever did try to find out who the source was until Dan Ellsberg revealed it himself after the papers had been published. I looked at Watergate, this famous case that had been so important in my own life, and I was surprised that the special prosecutor there, Archibald Cox, had never sought the testimony of journalists. A lot of people think that somebody was trying to find out who the Post sources were, and indeed, if you listen to Carl Bernstein today talking about how when he was subpoenaed, he gave his notes to Katharine Graham because he knew that they'd be safe with her. What he neglects to mention is the only time he was subpoenaed was in a civil case involving the Democratic Party and the Republican Committee to re-elect the president. And it was a case that 8 of us received subpoenas on. Time magazine received a subpoena, and the district judge threw it out at that level. So it never went anywhere and really wasn't much help to us as we were trying to figure out what we did with Matt Cooper and Valerie Plame. I then started asking myself a related question, which is if you assume that the Supreme Court is either not going to hear your case or that it will turn you down, what is the right thing to do? Clearly, I respect the right of an individual reporter to do anything to keep a source confidential, to say nothing about it. I think an individual reporter absolutely has a right of civil disobedience. It's less clear to me that a corporation has a right of civil disobedience, or that particularly a publicly held corporation has a right to civil disobedience. Most of the corporate governance lawyers that I talk to, in fact, suggest that this is not something a corporation can engage in, and that if you were held in criminal contempt as opposed to civil, that you'd probably need a resolution from your board of directors saying that it was all right for you to ignore a contempt finding, something that no board I've ever run across would be very likely to give, especially if their director's insurance didn't cover it, and it probably wouldn't. So I was sort of stewing about this a little bit, and I was then asking myself also the question, when do you have the right really to ignore the law? And I started researching a whole bunch of cases that I thought were relevant to this discussion, although a lot of journalists don't. And it was kind of interesting to me to see that during the Korean War, Harry Truman was very upset when the steelworkers went out on strike because he thought that it was a national emergency. He needed steel for bullets, for ships, and he ordered federal marshals to go in and open the steel mills. And the steelworkers sued him, and the Supreme Court ruled unanimously that Truman did not have the authority to stop this strike, and that he could not, he was not, the President of the United States was not above the law. I saw another case in Alabama where the head of the state Supreme Court, Judge Roy Moore, was trying to get the Ten Commandments put into the Supreme Court building in Alabama, in Montgomery. And the New York Times wrote 3 editorials that said, we live in a country where the rule of law matters, and if the Supreme Court of the United States says you can't put the 10 Commandments in your courthouse, you must not do it. And I started asking myself, well, how are journalists different from Supreme Court judges, from the President of the United States? Well, we're not government employees, we're not elected officials, we're not appointed officials, we're private citizens, but still the notion that somehow reporters were above the law was one that I found difficult to deal with. I do believe that confidential sources are absolutely essential, and I think there are cases when, in fact, it ought to be important that you respect that confidentiality, and I think I'll give some examples of that. But as I came back to our own case, I found myself asking, sort of, has anything happened since Brandsburg that gives us a hope that the Supreme Court will hear the case? And if they don't, what do we do? Well, we found a few things that happened since then. One, in 1975, John Mitchell, of all people, Nixon's Attorney General, who was never thought of as a friend of the press, promulgated some guidelines for the Department of Justice that severely restricted when justice employees could seek testimony from reporters. And always said testimony for reporters should be the last thing you do, not the first thing you do. Secondly, the rules of federal evidence were changed in 1975 to say that there ought to be a balancing test for when evidence is admitted in court. And since then, the Supreme Court had ruled in 3 instances at least that the needs of society for confidentiality outweighed those of the need for testimony. One is confidentiality between spouses. A second is between a lawyer-client privilege. A third created a privilege for clerics and penitents, and a fourth for therapists and their patients. And it seemed that I thought we ought to at least try with the Supreme Court to say, well, if you're going to let therapists and their patients have confidentiality, what about reporters and confidential sources? In addition to that, one of the things that Justice Roberts had said in Brandsburg was that there was no empirical evidence that reporters even needed confidential sources, and secondly, that there was no suggestion, at least at the state level, there wasn't widespread creation of privileges for reporters. And in the 33 years since then, that has changed extraordinarily. We now have 32 states that have shield laws for journalists, giving them some ability to keep their sources confidential. In the District of Columbia and in New York State, that privilege is absolute, and there's no way in which it can be defeated. There are also about 17 other states that have found a common law privilege just in the court decisions that give some protection for journalists. And so we were saying this would be a good time to try to get a shield law passed, but also a time when the Supreme Court ought to go along with these states and use a common law basis to overturn Brandsburg. We succeeded in getting the attorneys general of 35 states to write a brief as a friend of the court saying the law is so confused you ought to take a look at it and you ought to overturn it. All that said, it became pretty clear to me sometime in May that we were not going to get the Supreme Court to take this case because the Court of Appeals had voted 3-0 against us, and there was no other Court of Appeals that had a contrary opinion. And it just seemed to me that it was unlikely the court was going to be willing to hear this. There's something about filing cases that get heard where they have to make a decision in June, where the rush to recess is about as strong as it is in the Congress, and it just didn't look very good for us. And so I started asking myself finally the question, if you do believe that confidentiality is important to do your work, are there times when you would clearly say that the confidentiality should not prevail? And we've seen some examples of it. Jonathan Alter at Newsweek several years ago had an interview with Oliver North where North gave him a lot of information about Iran-Contra. And then a week later, Ollie North, on the steps of a courthouse, talked about how we have to go after all these terrible leakers. And Alter took the position that he'd waived his confidentiality by saying this. I'm not sure I really agreed, frankly, with that one, but that was one decision. Milton Coleman, the city editor of the Washington Post, had a private conversation with Jesse Jackson when Jesse was running for president, where he referred to New York as Hymietown, a reference to the large number of Jews who were there. And Coleman decided on his own that that was so newsworthy that despite the offer of confidentiality, he would go ahead and print this story. The New York Times, which is probably the most strident about confidentiality, has often said that if, for example, a reporter was given confidential information about enemy troop movements, that would be an obvious area where you'd want to forget about your pledge of confidentiality and reveal this information. The typical example that's often been referred to in this state is if you had a child who was kidnapped and you had the information on the whereabouts of that child, you would clearly blow your source so that justice could prevail. And while the case that I was dealing with had none of the drama of any of those suggestions, the fact that the privilege was not absolute meant that I had to think a bit about what was going on in our specific case. And what I finally concluded was, first of all, the Supreme Court did turn down our petition to hear the case on June 27th. And as a consequence, I interpreted that as tantamount to a Supreme Court ruling against us. So we had a Supreme Court deciding that we were in contempt and that we should testify, and I could find no example in this century of a media company defying a Supreme Court decision of any kind. Secondly, we had the situation where, even though I was unclear what law had been violated, it was very clear from all of the special counsel's testimony that national security was an issue that he was looking into, and that he was looking into violations of felonies, of laws that we consider felonies, by high officials in the administration. And that seemed important to me. Thirdly, I started thinking about what the purpose of confidential sources are. And in my mind, at least, I always thought of a confidential source as somebody who gave a reporter information that was really in the public interest, that was worth publishing, and that in giving that information, the source was putting his or her own livelihood, reputation, even life at risk, and that's what confidential sources did, and that was what deserved this kind of protection in litigation. In this case, what we had was really a couple spin doctors for the administration who were actually trying to destroy the credibility of a whistleblower, Joe Wilson. And so the question in my mind is whether confidentiality really should have been granted in this case to begin with. And then finally, we had a problem, which is something that has to do with modern technology, and that is that Matt Cooper, our very solid journalist, had put the names of his sources in email. And as such, more than 30 people at Time Inc. knew the names of the sources. In addition to that, he had been so excited about getting the sources to give him this information that an awful lot of other reporters in the Washington Bureau knew about it. And so, whereas I respected his individual right to want to keep the confidence, institutionally, I was facing the possibility of a special counsel serving subpoenas on more than 30 people in the IT department, working on the website, working in Washington or in New York bureaus who never had anything to do with the story. And I had to decide whether this was the case where it was worth going through all of that. The final thing that I had to focus on, and this was something that was not public, was the fact that the special counsel had made it very clear to us that he would try to get us held in criminal contempt if we refused to turn over the information. And this is a little bit arcane, but the general rule about civil contempt is that the purpose of civil contempt is, you're not found guilty of a crime. The purpose of civil contempt is to try to coerce behavior. And there is, frankly, a long tradition of journalists saying, we're going to stand up to this kind of coercion, this is why we go to jail, this is why we'll pay fines. Criminal contempt is a finding of wrongdoing, and under the federal law, you can be held in jail for up to 6 months without a trial, even though you've been found of violating a crime. And it is in criminal contempt particularly that I think corporations do not really have any opportunity to resist it. So as much as you might very well want to keep your source confidential, it may be very tough if you go that direction. In any case, we decided, and I decided more accurately, since it was the way things work at Time Inc., when you ask what the editor-in-chief does, what I did was make this decision unilaterally without really taking it up with any of the people at Time Warner or Time Inc. on the corporate side. I decided that this was a case where it was appropriate to turn over the notes after the Supreme Court turned us down. The New York Times took a very different position, and there are a couple of reasons that ought to be explained. First of all, Judy Miller, an individual, was held in contempt, but the New York Times as a newspaper or company was not. And in that respect, their case was very different from ours. There was no issue of corporate or institutional responsibility. There was a reporter who was defying a court order. Secondly, and I found this rather fascinating, the editors who worked with Judy never looked at her notebook or never talked to her about who her sources were. And if you looked in her notebook, you'd see the words Valerie Flame with a question mark next to it after following her. And it's the same notebook in which she had her interview with Libby. So there was a question there. Thirdly, Libby clearly thought that he had granted Judy Miller a waiver, and that with that waiver, she was free to testify, but nonetheless, she took the position that any waiver from a confidential source of hers was, by definition, coerced and therefore to be ignored. And so she did go to jail for 85 days. I've tried to understand what it was that led her after 85 days to actually go back and get that waiver and subsequently testify, and I can't speak for her, but I do think that it was becoming pretty clear that her sentence might go beyond the time of the grand jury, and she might be there longer than the 4 months that she'd bargained for, given the threat of criminal contempt. When I come out of all of this, I think there are a few things that I've learned about journalism, and I guess a couple of things that I would suggest going forward. One is that if you ask a group of editors across the country or a group of journalists across the country, what's the difference between not for attribution, background, deep background, off the record, and confidential, you get all kinds of different answers. There's no standard. I mean, this is partly because anybody can be a journalist. You don't have to take a test or get a license. Secondly, because these rules are not really codified. And I think it is important that we have some common understanding of what we're talking about. In general, not for attribution means you can't use my name, but you can identify me in general terms to give the reader some belief that there is an actual person you were speaking to. So if you see something in a newspaper that says a White House official or a State Department source, that would be an example of not for attribution. Many people think background is the same thing. I interpret background as meaning that you can put it in quotes if you want to, but you've really got to be a lot more circumspect about the sourcing, or you ideally should find somebody else who can confirm this for you. Deep background to me means that you really cannot identify anybody on deep background. If you believe the source, if you've seen the documents that are given to you on deep background, you might use them, but that you should not attribute to anyone. And off the record really means that you shouldn't be using it, although anybody who tells you something off the record knows you're going to try to find it out some other way and some other place. All of those terms, however, to me, go to the question of anonymity within a publication and don't go to the issue of litigation and what confidential source status is about. To me, a confidential source is someone whom a journalist has made a contractual relationship with. It is a relationship that it not only involves the journalist, but the journalist's publication or broadcast network. And it is one where there ought to be a very clear understanding between the reporter and the source about what has been granted and where it would apply. Does it say, under no circumstances will I ever discuss this person's name or make it public? Does it say, I will keep this confidential, but if we're held in contempt, I will ask you for a waiver? Does it mean, I will keep this confidential, but if necessary, I expect you and I both understand that the publication will in no way be able to give up your name under any circumstance. And I don't think there's been much discussion or understanding of this within the media at all. There are very few times, there are a couple of things I think that have to be understood. One is that if you're interviewing somebody and in the middle of the interview they tell you something and they say, now are you going to protect me on this? The last thing you want to do is at that point start talking about the various rules and what are we talking about by protecting you. There's no faster way to queer a conversation than to ask that at a time. Although the Dallas Morning News in its editorial guidelines talks about Mirandizing your sources and says that before you agree to take information that is not attributed, you have to explain the various ground rules and say what the paper will and won't do. But most times you don't hang up the phone and immediately put something on a wire. If it's so important that you're going to grant somebody confidential source status, for one thing, you're going to have to, at most publications, you're going to have to tell at least one editor who your source is. I would not let information in any Time Inc. magazine where the reporter was the only one who knew the identity of the source. That's how the New York Times got Jason Blair, and that's the kind of thing that I think has to be avoided under all circumstances. I think the second thing is that there ought to be an opportunity to go back to the source and say, okay, what's really important to you here? Is it that we take this information and that we not print your name in the article, or is this something where you are at such risk that we just can't tell anybody about it, because we'll then have to make a decision about whether we're willing to take that risk on our part and print the information or whether we'll do without it. And I just think that conversation doesn't take place. The other thing that I think we really do need is a federal shield law, and this is very tricky because the First Amendment talks about freedom of speech and it also talks about freedom of the press, and I think one of the things we have to ask is in articulating free speech and free press, did the framers mean to suggest that the press had a freedom that went beyond that of individuals, or were they just reiterating and reinforcing the idea that the press ought to be as free and vigorous as possible? A second thing that comes up is a question these days of who is a journalist. We have 20 million bloggers in America, and is every blogger a journalist? And if so, does the privilege extend to everyone? A lot of people who have tried to interpret the law say, well, you have to be writing for a living, you have to be writing for a publication as such. But I don't think that the framers of the Constitution were thinking about big media companies when they were talking about the First Amendment. They were talking about the lonely pamphleteer, about Peter Zenger. And I think one of the very real questions we'll have to struggle with as we try to come up with a shield law is whether one can be crafted that does not really, if you will, vitiate all rules of evidence in an effort to protect everybody who is self-described as a journalist. And I think that's a hard thing, but we've managed to do it in a lot of states in a way that seems to have worked. And I think as we push forward to try to get a federal shield law, we're going to have to address this issue. As much as I think that shield law is necessary, I regret to say that I think the chance of it passing anytime soon is not very great. And part of the reason for that is, frankly, that the public has come to think so much less of the press in the 30 years since Watergate. And I think part of the reason for that is, frankly, the fact that we have been so willing to take information from anonymous sources and to do things that have otherwise undermined our credibility. When I testified before the Senate Judiciary Committee this summer over a bill that was introduced by Congressman Pence and Senator Lugar, both from Indiana, only 9 senators had signed on to this bill. And while I think that the testimony may have swayed a couple more, and while I think the Liddy indictment, the possible indictment of Karl Rove, the Liddy case, and his lawyer's efforts to get even more journalists to testify all may stimulate some interest on the part of the Congress in passing this law, I don't really see it happening anytime soon. So as a consequence of that, I think we do have to acknowledge that this is a far more complicated, far more difficult area than I had thought it was. The reason I call it the most difficult decision that I've ever had to make is because I think that very many journalists would have made a different decision, including some editors whom I've considered role models. But I do think it's a dialogue that's an important one, and that we need to have a better understanding between journalists and their sources, and even more importantly, between the media and the public about what we're talking about when we use information from people and we don't attribute it to them. So with that, I will happily take any questions that you might have, and I'm grateful to you for coming this evening to hear about this story. Thank you.